Why every Social Security disability applicant with reactive arthritis should have an attorney represent them. If your doctor has told you to stop working and apply for benefits because of your reactive arthritis, you owe it to yourself and your family to consult with a Social Security disability attorney. The initial application is designed, I think, to be confusing, and in my opinion doesn't always ask the right questions. For example, the application asks questions about your work history, but doesn't really give you an opportunity to explain how the psychological problems that you might have with your reactive arthritis interferes with your ability to do your job, or more importantly, how your symptoms may prevent you from meeting the pace and production requirements of your occupation. So many times people make a mistake in the initial application because they really aren't fully explaining their occupational duties. And worse yet, at the initial application stage, if your medical records just don't explain your functionality, what you can do despite your reactive arthritis, the Social Security Administration defaults to a functioning level that lets them deny your claim. Now, you only are going to have 60 days in which to file for a request for hearing if your claim's been denied. And if your claim is denied again, you'll have 60 days in which to file for a hearing. And a hearing means a trial. A trial is a trial is a trial. Well, what do I mean? There are going to be two people at that hearing, other than the judge, you and a vocational evaluator. You want to be prepared so that you understand the 5-step sequential evaluation and how to tell your story to the Social Security Administration, not only truthfully, but within a context of those 5 steps. You also want to have an attorney gather your medical records, get a residual functional capacity form, prepare a hearing brief if needed, and be prepared to cross-examine the vocational evaluator, that other person who's in the hearing. The judge is going to be formulating a hypothetical and turning to that vocational evaluator and saying, I want you to assume the applicant, much like this person here, has a residual functional capacity of being able to lift 10 pounds, sit 6-8 hours out of an 8-hour day, have to change positions once every 2 hours for 5 minutes. The question that the VE is going to ask is, can that hypothetical mythical person just like you go back to that lightest physically demanding job? And more often than not, the vocational evaluator will say yes. And that means you lose at step 4. Now, if the judge doesn't modify the hypothetical, or if the answer is no, you can't go back to the lightest job you held in the 15 years before you became disabled, the next and crucial question, the question that will determine whether you get benefits or not, is at step 5, is there any other work this mythical hypothetical person can do in the mythical hypothetical national economy in view of their age, education, skills level, and residual functional capacity? Now, I often hear 3 dumb jobs from vocational evaluators who will testify about other work they think this hypothetical person like you could do. And it doesn't matter that you may not be interested in this job, there may not be a lot of openings, or that even it would pay a living wage. But the answer to that question can make or break your case. And if the vocational evaluator says there are other jobs and the judge stops there, guess what? You lose at step 5. You need to have an attorney who can effectively cross-examine that vocational evaluator. It's a make or break issue. So before you stop working or appeal a denial of your claim or try to go to hearing on your own, call me today at 727-894-3188 for a complimentary consultation. You owe it to yourself to learn more about your rights to Social Security disability benefits for reactive arthritis.